His new book, An American Yankee, King Alfred's Court, is a legal memoir that blends courtroom drama, travel writing, and a moving story of mentorship, mortality, and the English barrister tradition. Let's give him a warm welcome, Mr. Dennis.
Okay, start with a brazen push from my first book, which I talked to you about a while back, is What Did You Do in the War, Sister? And that is about how Belgium nuns deceived and defied the Nazis in World War II. And it's historical fiction, but it's mostly true type of thing. So I have a couple of those left. But we're going to talk to you today about the book American Yankee and King Alfred's Court. So the ground rules for any talk that I give is that there are no ground rules. Ask questions whenever you feel the urge. And I like questions, the more challenging, the better. Questions delayed are questions lost. And of course, I am a law professor, so I may ask you questions too. Let me first start with a disclaimer. You know, the book is entitled American Yankee and King Alfred's Court. And when I gave my first talk about this out at the Oakwood Library, they sort of took literally King Alfred's. And of course, the dates of King Alfred are about 850 or 860 or so. And so there really would not be much to talk about with regard to trials in 850, because the trials then were rather simple. There was no need for barristers or solicitors or lawyers or anything, because if you were charged with a crime, they just tie you up, throw you in the water, and if you sank, you were innocent. If you floated, you were guilty. Now, presumably they had a rope to you, so if you sank, they could get you back up. But it did eliminate the need for trials or any other kinds of procedures, because it clearly decided, as far as they were concerned, who was guilty and who was not. So this is not about King Alfred's name. For King Alfred is in this book because the time I spent trying cases with British barristers was primarily in Winchester, England, which was the capital of England at the time of King Alfred. So that's how the title got where it is. And of course, of a little bit of nod to Mark Twain and the Connecticut Yankee and King Arthur's Court. There's a little bit of that. So let's deal with the issue that everybody wants to deal with, is the wig issue, right? No, that's not my wig. In fact, I didn't wear a wig. This was a wig given to me by law students at one point. So this is more of a traditional barrister's wig. They got little ponytails and little tails at the back. Sometimes they add little ribbons and that. But that is more or less a typical British wig at the time that I was mostly over there. And then this would be a judge's wig. They have now changed these wigs a lot. It used to be, you could tell how important the judge was, in other words, how high they were in the judicial scale, by the length of their wig. The longer the wig, the higher court justice they were. So, but they now have much shorter wigs. And you notice how his glasses are? I would swear that they must teach that in judge school. Because, you know, in a British courtroom, in the older British courtrooms, the judges sat up there on this pedestal like gods. You could not even hand something directly to them. You had to hand it to somebody intermediate who would then hand it up. And they have this technique. It's always, if they're going to chastise you, they always look over their glasses like that. Just like that. They look over, stare at you, chastise you. From coming on high, it's usually a pretty significant chastisement. The other thing that's sort of talk about initially, so you can understand how the system works, is the difference between solicitors and lawyers. In this country, lawyers do everything, or they think they can do everything. So they will You might go there for them for a contract or a will, or if you've been charged with a crime, you might go to them to defend you. And if you go to court, that lawyer will defend you in court. In England, they divide those responsibilities. Solicitors are your transaction lawyers. They're the ones you go to for contracts, probate, those kind of things. And if you're charged with a crime, you go to a solicitor first. The solicitor will then hire the barrister. The client does not hire the barrister. The solicitor hires the barrister. It's also a fact that solicitors make a lot more money than barristers. Barristers get to wear the finery, so when they're in the courtroom or in the courthouse, they've got the peacocks, you've got the robes and the wigs, and they're the peacock and the cocks of the walk, but they don't make the same money that solicitors make. But that's how they divide the work. Don't go to a barrister and say, gee, could you do me a will? And they would just look at you strangely. What do you mean? I don't know much about wills. Don't ask me about contracts or anything like that. So that's the difference between the two. So this book came about rather serendipitously in that I was at a conference for an American Association of Law Schools. And like those of you who've been to conferences, you know what much of what goes on there is either talk and drink or drink and talk and schmoozing and networking and all that stuff. So I was talking to a law professor, and he was saying that he was both a barrister as well as a trial lawyer here in the United States. He says he worked both sides of the pond that way. And after my second glass of wine, I said, oh, that sounds like something fun to do. How did you do that? Well, I became a pupil of a barrister over in England, and I served a pupillage with a barrister in England, and then I got admitted to an Inn of Court in England and that. So that's how I did it. So I said, oh, gee, I might be interested in that. And he said, oh, send me your resume, your vita, and I'll pass it on to the chambers that I worked with. So I did, thinking that what he said was pretty much a pie crust promise, right? Easily made, easily broken, and didn't think much more about it. But a month later, I got a letter from a barrister in Winchester by the name of Jeffrey Still, and he said he'd take me on as a pupil. So my bluff was called. So I had to decide, do I take my family to England for 6 months to a year and do a pupillage and that, or do I turn it down? So I accepted. And so we went to England. Our younger daughter at that time was 11 years old, and my wife and I, we went to Winchester, and I started my pupillage with Jeffrey. That still doesn't get me to the book, however. About 2 years ago, I got an email from Jeffrey, and he said, well, Dennis, probably not going to be able to see each other again. I'm dying of cirrhosis and hepatitis, and I've got about 2 months. He said, probably from eating too much foie gras, or goose liver, he said. He kept his sense of humor. And I had the idea that I would send him copies of the journal I kept during our time working together on cases. And because I kept an extensive journal, I thought that would be kind of a thing to send him to kind of remind him of all the good times we had together, both in and out of the courtroom. And my wife, Kathy, said to me, she said, well, Dennis, that's a book. Okay, well, yeah, well, it has the making of a book. So I created a book out of it. The book is a fictional memoir of sorts. By making it fictional, I can indulge me to create more interesting characters, dialogue, and that sort of thing. And then some of the cases that I refer to in this book are cases that were tried by other barristers, not necessarily Jeffrey. But the main theme was that my time with Jeffrey was a life-changing experience. And that part is absolutely true. So this is my first introduction to Jeffrey. And the book, I call him Giles. One of the hardest things about this book, there's a lot of people that are talked about, right? They have pretty strict privacy laws in England. So they all had to have fictitious names. And with that many characters, there's a lot of names you have to come up with that are fictitious names so that nobody can follow the crumbs and say, oh, he's talking about me, and that. So it makes sense to make them all fictional that way. So Giles swooped into the room, which is the only way to describe his entry. He was almost as tall as me, wearing a dark gray pinstripe suit. He was thin, with mostly unnoticeable paunch. His face was aquiline, punctuated by a hawkish nose, centering his faded blue eyes. It was his hair, however, which dominated his appearance. He had a full head of cheek-length blonde, perhaps slightly highlighted hair, like a lion's mane. Giles clearly considered it a distinguishing feature. Rather than use his hand to brush the long locks out of his eyes, he would give a quick toss to his head, flipping the wayward wisps back into place. How long it had taken Giles to master that skill? Did he ever have to repeat the head toss, spoiling the performance? It would be like a magician needing to reach into the hat twice to pull out a rabbit. The interview ended just as abruptly as it began. Giles stood up, extended another brief handshake, and rushed out of the office in the same grand manner. I was left standing in his tacky office, wondering what had just happened. The only clear thing in my mind was that Giles must have accepted me as his pupil, but the nature of the relationship was nebulous at best. I had the weird and unnerving feeling that I was about to become a small planet captured by the gravitational pull of a much larger planet, and I soon would be a satellite circling planet Giles. I pondered my potential orbiting fate. If I had any chance of resisting Giles's force field, I had better escape immediately before the laws of physics made escape impossible. Jeffrey was one of those larger-than-life people. There's no question, both in and out of the courtroom. He had an ego that was enormous. He was the kind of person that I never would have been friends with in the States. And you might have invited him to a dinner party as an interesting person to have at a dinner party, but you never would I have been able to make friends with him because it's very hard to deal with people of that ego. And yet we became friends. And we became a very good team of trying cases together because barristers are in court all the time. That's all they can do. If they're not in court, they're not making money. So they're always trying cases. And one of the neat things about the British system is and you're in the criminal side of things, you're sometimes prosecuting and sometimes defending. There are no professional prosecutors or professional defense counsels. Barristers for criminal do both. And that creates a different kind of atmosphere than in the States. So we had some very, very different strange cases. And this case was not actually tried by Jeffrey, it was tried by another barrister friend of mine, or it was involved. And I would call it Murder Most Flawed. And another way is Abbott and Costello meet Lady Macbeth. The tarantula plays some part in this story because the woman, we'll call her Lady Macbeth, who wanted her husband killed, in part because he kept pet tarantulas as pets. And he would exercise them around, and once in a while he'd put one on her pillow to kind of show her who was boss. And so she got tired of this, And so she wanted him knocked off. Now, I'm not making this up. And ultimately, she was charged with attempted murder and jointly with Abbott, we'll have to call him Abbott and Costello. So she went and asked Abbott, was a next door neighbor. Apparently, he was already a bit of a thug. And she told him, says, I want you to knock off my husband. I'll give you 2,500 pounds for it. He negotiated a little bit, and he says, make it 3,500. So they agreed. He agreed. He says, I'll get rid of Macbeth for you for 3,500 pounds. So he goes and talks to his friend Costello. And he tells Costello about the plan. He tells Costello what Lady Macbeth wanted, and they negotiated a price. Costello wanted 1,000 pounds. He got it, so out of the 3,500, he would get 1,000 pounds for knocking off Macbeth. And they concocted a plan. They thought it was a foolproof plan. But you were dealing with Abbott and Costello here too. So their plan was they were going to get Mr. Macbeth drunk at the pub one night, and they were going to propose to him a plan. They're going to say, Macbeth, you can earn a quick 500 pounds tonight if you help us unload a boatload of marijuana down off of Chesil Beach. Now, again, remember, this is back in the 90s, so marijuana was still illegal, and you couldn't import it in England. He says, so you can just help us do that, and you can earn a quick 500 pounds. So Macbeth is rather drunk, and he agrees to it. Now, the only problem with Chesil Beach in this neighborhood is the beach is 100 to 150 feet down from a cliff. Now, you can get down there, but it's quite a drop. So the plan was, they have him drunk, and they go to the beach, or the cliff overlooking the beach, and Costello is supposed to say, oh, is that the boat? So when Costello says that, Macbeth is supposed to look over, and Abbott pushes him off. Pushes him off. There's a scream, and they take off. Oh, good, it's done. But 30 feet down, there's a bush that sticks out from the cliff. It caught Macbeth, and he was able to hang on and work his way up to the surface. And at first he thinks, well, I'm going to go tell the police. Well, then he goes to the police station and he starts telling the story about being pushed off the cliff, and he was still drunk. And then they ask him, well, what were you doing out there on midnight? And he realized, uh-oh, am I going to say I was there helping import illegal drugs? And he walks out of the station. So he goes home. He doesn't know his wife, and he goes into their apartment, to their townhouse, gets in and goes into the bedroom. Lady Macbeth sits up in bed and says, what are you doing here? And it's a little strange. He feels it's a little strange. Well, I live here. I sleep in this bed and that. But he did know that it was his neighbor that had set him up. So he goes next door with a cricket bat, and he's pounding on the door, but Abbott is smart enough not to open the door and lays low. And the next day, he takes off to another town to live. Failed attempt. But Abbott now says to Costello, I've got a plan B. This is really foolproof. And besides, we have even more motivation to kill Macbeth now, because now he's going to accuse us of attempting to kill him. Plus, we want the money. Costello says, well, I'll help you for another 500 pounds. So they agree to that split. And so here's the plan. Abbott tells Costello the plan. He says, We're going to steal a van from this van rental place, and then we're going to go to the hill overlooking the pub where Macbeth works. In those days, pubs closed at 11 o'clock, and he'd have to leave the pub, and he had to cross the road to go home. So they said, we'll sit there at the top of the hill. When he comes out and crosses the road, we'll run down the road and hit him and kill him, and then we'll take the van back to the thing. And, that's how we'll do it. So they work that way. They get the van, and they're sitting at the top of the hill. The pub closes, and there's a person walking across the road, and they're staying down the hill, zooming 15 yards from the guy. They realize it's not Macbeth. So they turn off, slam on the brakes, and get into a bush. A bush stops them. The man he almost hit was pretty nice. He helped them push the van out of the bush. And then they take the van back to the yard, and Macbeth is still alive, obviously. So now Abbott comes to Costello and says, I got to plan another plan. And Costello listens very nicely, and then he remembers his mom saying, you can fool you once or fool you twice, but then you shouldn't get fooled 3 times. So he listens, but then he goes to the police and tells them the story of what happened. At first, they thought he was crazy. He's talking about tarantulas and a guy falling off Cheslow Cliff, and he was hit by a van, but he wasn't hit by a van. But then somebody remembered, wait a minute, I remember some Beth or some guy coming in and talking about this. Maybe there's a connection. Well, anyway, they connect the dots, and they charge all 3 of them with the crime, and Costello pleads guilty to the crime. And it goes to trial, and the fascinating thing about this case, for me as an evidence professor, is that it really turned on the hearsay rule. The hearsay rule says we don't like statements that are made out of court, and for the truth of the matter, we want to have live testimony. And the only person who could say what Lady Macbeth said is Abbott, and he's not talking. And Lady Macbeth isn't talking. So they weren't able to pin it to Lady Macbeth. And she was ultimately in the appeals court was found not guilty. And then the final thing to this story was the Macbeths made up. They reconciled. And they sold their story to the Daily Mail for 20,000 pounds. So that was like one of the cases dealing with in this book. And again, many of those. And I can talk about differences in the 2 systems. One of the things that people are very interested in is how their system varies from ours, and the kind of things that I really liked about their system. But it's also, the story is broader than that, because Jeffrey, as I said, is a larger-than-life person, and I was able to meet people that I never would have had an opportunity to meet before. He had a chateau in Normandy that would take us over to be in Normandy for weekend or whatever, and meeting some very interesting people. One of the persons that we met was a woman named Ellie. Well, my name is Ellie. And she was a Michelin chef. When you dined with Jeffrey and wined with Jeffrey, you always had the best. He was a connoisseur of wine and food. So Ellie was one of the friends who was going to be cooking at this weekend. She was a Michelin chef. She cooked for the royal family in Scotland. And she told the story of how Prince Philip liked to fish, and he would carry he would catch salmon. And if he caught a salmon, he'd bring it down to the kitchen and to have it prepared. And he liked it prepared in puff pastry. He had a special way he liked it. And he would bring the salmon down there. Well, my experience with Ellie at the chateau was she didn't want anybody in her kitchen when she was cooking. And I asked her, I said, well, what did you do with Prince Philip standing there while you were trying to cook? Did you kick him out of the kitchen? And she said, Dennis, the last chef that did that had his head stuck on a pike outside of the front gate, and I didn't want to test that tradition. So Prince Philip would stay there. So another interesting character I met at one of these dinners was a woman named Troy. And for as a little background, she was going to be married to this barrister who was also there, who, if Jeffrey had a big ego, this guy had an even bigger ego. He said, quite blasely, that I'm probably one of the best barristers in England. Sometimes I make 18,000 pounds in a day. And he started ranting about the houses he owned. And he also thought himself very good looking and kind of indicating Troy, who he was going to marry, who was 20 years his junior. All right? So one of the things that Giles had in place for these dinners was you rotate it. So I'll just read that part. So Giles decreed before dessert was served that anyone could change their seats, like in musical chairs, so there would be a chance to converse with new people. As luck would have it, the new person sitting on my left was Troy. I was feeling euphoric from consuming too much wine, so I was acting less than tactful when I asked Troy, I saw you do an eye roll when Michael, the barrister, was telling us about his houses and his yacht. Troy may have had a surfeit of wine too when she chuckled and said, I need to control that if I'm to become a good trophy wife when I marry Michael. I must practice my fawning and adoring mannerisms. Well, for me, trophy wife was a derogatory term, akin to being a paid escort. And the diplomatic side of me wanted to give Troy the opportunity to back away from her self-condemnation. Surely you do not consider yourself a trophy wife. Troy did not backtrack and said, I do not know what else you can call me. She then outlined the arrangement she planned to have with Michael after their marriage. Troy described it as a business relationship with a bit of sex on the side, which she added had been tolerable up to that point. She understood she would be just another of Michael's showy possessions, like his houses, his yacht, and his Rolex. Troy's role was to play the attentive spouse at parties and events while Michael drummed up future business with solicitors and clients. Troy added that she was good at flirting with potential sources of income, just as she was flirting with me. Rather than engage in the game of ambiguous flirting, just tell the man you're intentionally flirting with him. I was puzzled and could not resist asking, why would you choose such a life? Troy explained the why. She said she was 35 years old and had 4 children under the age of 10. She had no education beyond secondary school and had little prospect of ever being more than an unexceptional, poorly paid dress designer. The husband she was divorcing in a week was an unemployed truck driver with a gambling habit. With Michael, Troy's children could attend the best boarding schools, such as Winchester College, and have a reasonable chance of making the jump to Oxford or Cambridge. As for herself, she would live a luxurious, pampered life with servants to do most of the chores. There would be the bonus of Michael being gone for weeks at a time, trying cases in places like Manchester, Leeds, and Edinburgh. Then Troy winked at me and whispered, it'd be okay with me if Michael had occasional fling on those trips. Troy was confident she could hold her own with Michael. She said his inflated ego was also his greatest weakness. By stoking and feeding it, she could get her way. A bit of the fawning, adoring wife act went a long way. As for Troy's long-term future, she had a realistic and pragmatic perspective. She thought with proper dieting and long gym sessions, she could maintain the glitter for 15 years. By then, Michael would be 70 years old and she would be 50. At that point, Michael might be willing to retire and settle down for the rest of his life. On the other hand, if Michael went on the hunt for another young trophy companion, she would be happy to step aside for the new woman. The divorce settlement would ensure her a comfortable life without the need for a man. If she decided to remarry, Sally said she was confident of attracting a man. She admitted that at 50 years old, she would not be for all markets, but would still qualify for the high street trade and not be forced into the discount shops. My conversation with Troy may have been one of the best learning experiences of my sabbatical. I discovered that it may be true that all that glitters is not gold, but sometimes things and people who glitter are gold. So that was one of the people that I ran into through Jeffrey. So I'm going to ask you questions. I have a list here of differences, and I'm going to let you all pick which one you would like me to talk about. So the guns or lack thereof is a huge difference in England. You know, there's restriction on gun use. Prosecutors and judges, police interrogations, bonds, selecting a barrister, plea bargaining, sentences, jury selection. There's no prepping of witnesses. The 10-step summation takes some explanation, but it's one of the biggest differences that I found between the two systems. The civility of the barristers to each other, because it's a very civil way of trying cases. Judges' summation of the case and appeals. In this country, when you're trying a case, you prep your witnesses. In other words, you sit down with your witnesses and you go over the questions that you're going to ask. And you don't tell them what you want the answers to be. You're not allowed to do that. But you hear what they say. And I might give you a quick example. Let's say you're talking about some injury, somebody's injured, and you want them to describe the injury. And you say, well, how did it feel? And the laconic person says, somebody stoic like yourself, maybe, would say, it hurt. Well, let's see, that is not going to get into very six-figure judgments at that way. Could you be a little more descriptive? And you'd say, oh, it felt like an ice pick going into my, oh, good, I like that. Okay, keep that. So that's how you prep them. You're not putting words in the mouth, you prep them. In England, you're not allowed to do that. You can't sit down and talk with your witnesses of what they're going to say. So you get faced with the situation is you're not always sure what they're going to say. And it can be quite surprising sometimes. And I'll give you the example of what happened in a case that Jeffrey and I worked together on. By the way, we never lost a case, whether we were prosecuting or defending. So we were a pretty good team. But anyway, this was a case dealing with blackmail. A young man was blackmailing an older man who was, it's hard to describe how despicable he was. He had groomed this young boy from 12 years old. He was a pedophile. He had groomed, and then at the time when he got 18, he broke away, and he sent a note to this man. He says, I'm going to tell the police unless you give me 6,000 pounds. That's pretty much like blackmail, isn't it? I mean, no matter how onerous or how awful the person you're blackmailing is, it's not a defense to say, I'm really blackmailing a terrible person. You can't do that. So our defense that we came up with, what could our defense be? So our defense was, he's a young, mixed-up kid, and he's heard a lot about compensation and how people get compensatory damages for injuries they've occurred, and that's all he's doing. He just wants compensation for the injuries. It sounds like blackmail, but he had no intent to blackmail. He just wanted compensation for the injuries. That was the case. So the defendant gets on the stand. Again, we didn't prep him. We haven't prepped him. But we thought he's smart enough to figure things out from sitting and watching the trial the whole time. And so Jeffrey asked him, he says, well, we'll give him the name David. David, if you would have received the 6,000 pounds, would you have been satisfied with that? And he says, no, I'd have taken him for everything I could get. The classic blackmail line, right? So Jeffrey gave me the owner's job. He says, go back at the recess and talk to him in the room and tell him to bring his toothbrush and his underwear and that, because he's going down. He has just given the classic blackmailers line. And I went and told him that. I said, you're toast, man. But Jeffrey pulled it off. Jeffrey pulled off one of the amazing things. He grabbed, on the next day for his summation, he grabbed a bunch of pamphlets from the courtroom, on the atrium out in the courts. And they were all about how we need to protect children against pedophiles, and how social services should look after them, how teachers should, and how parents should be aware of this sort of stuff. And his whole speech was, ladies and gentlemen of the jury, we failed this kid. It's our failure to do what we were supposed to be doing, and that's why he's here. And what Jeffrey was doing was something that judges absolutely hate. He was looking for a not guilty verdict called jury nullification. In other words, you're guilty of the crime, but the jury feels that you just shouldn't go to jail. So they don't have anything to do with sentencing, right? The jury. So the only thing they can do is say not guilty. And sure enough, that jury came back with a not guilty verdict in that case. Then the final little episode in that case was, I don't know if Jeffrey was pimping the judge a little bit. It's not a good idea to pimp judges in England. But anyway, he asked the judge for costs, because if you win the case in a criminal case and you can ask for extra cost. And the judge did his thing that I showed you over there. He looked at it, he says, Mr. Still, you are very lucky to have won this case. Don't push your luck. And that was it. So that would be a case of not prepping, and sometimes you get surprised by not being able to prep your witness. Yes? In England, there is no voir dire. You cannot talk to the jurors. In fact, in every case we had, the 12 jurors that were in the box were the 12 jurors you got.
And how are they selected there? Is it any different than here?
They're selected from voting pool, and that, and there's not much vetting. So the only voir dire that occurs as such, or any ability to excuse a juror, and again, I never saw any juror excused, was each juror stands up and swears by themselves to abide. And the defendant has said, is there any reason you object to this juror? Well, what's the defendant know? I mean, if it's a buddy that he's been in the pub with, you think he's going to say, oh yeah, that's my buddy from the pub. So as you might expect, one of the issues that you would think would crop up is a hung jury. Because if you only need one or two rogue elephants in the jury box to hang up the jury. And enough of you probably have seen 12 Angry Men, where one person holds out and they convince the whole group. It doesn't happen that way, but it's a good story. So in England, if it comes back and they can't seem to reach a verdict, in England how important tea time is. So if it's getting on toward tea time and the jury is still hung up, they can't reach a verdict, the judge will then give them an instruction and saying, ladies and gentlemen of the jury, you have not been able to reach a unanimous verdict. I'll tell you now, if 10 of you agree, it's okay. You can have the verdict. And so a 10-2 verdict would work. So that's how that system works with the juries. Good question. Other questions? Yes?
What are the gun laws?
To have a handgun, you have to go through a whole lot of procedure to registration, and then, of course, you can, but then they know from the striations, if it's ever been used and they find a bullet with those striations, they know how to find you, and it's very difficult to get a handgun. You can get rifles and shotguns, but you're limited to single shots or double shot shotguns. You can't get multiple, weapons. And it's such a great comforting feeling to be in a society. You don't have to worry if you bump into somebody, you have something that they're going to pull a gun on you. And in my first time in England, looking back on it, I can look back on how happy I was that people didn't have guns. Because when I first got to England, my first back in '84, I went to catch a bus. And I was, like an American in most buses, joined the scrum, I got to get up, and I was hoping to stand in the curb where the door opened so I could get on the bus early before other people did. That's sort of standard here in the US, right? You just do that. So I'm in position, and there's this on my shoulder. I've been hit by this umbrella. And a little old lady said to me, she said, "There is a queue." I said, "Oh, okay, I'll get in the queue." Now see, I'm thinking back on that, I'm thinking, in the US, there might have been a piece of gun in my back and say, "There's a queue." I'm taking an umbrella anytime. So it's really that the police don't carry guns. They have truncheons, but they don't carry guns. And again, that feels good. I like that. Other questions? Yes?
Police interrogations.
Police interrogations, okay. Because you've seen a lot of police interrogations in this country. The goal of so much interrogation in this country is not to get information so much as to get a confession. And they're going to put pressure on you. Now, I hope none of you get in trouble, but I'm going to give you a piece of advice. If the police ever want you to come down to the station to talk to you about something, get your attorney to go with you. Don't get into that room with them, because if they're calling you down there, you're already sort of in the frame. You're going to want your attorney with you. Because one of the things they can do, a lot of people didn't realize this, in America, during that interrogation, the police can lie to you. One of the more notorious cases is a defendant or someone who was a suspect made the stupid mistake of saying they'll take a lie detector test. So they took a lie detector test. They passed it. But when the officer comes back in, he says, "You flunked the test. Now tell us the truth. You flunked the test. Tell us the truth." So you don't want to be caught in that situation. So how do the British deal with it? When the police invite you down, you have an opportunity. Let me back up a second. In this country, they'll give you your Miranda rights. They'll tell you quickly you can have an attorney you want. But then along with that spiel is, but you probably don't need an attorney. If you ask for an attorney, it's going to be more suspect about, what are you hiding? And so, you don't really need an attorney. And then that's all they have to warn you about. They don't have to warn you again. So in England, when you go down, they have what is called a duty solicitor assigned to the police station. They're on duty all the time. They can be called. You can talk, and that's right there, to a solicitor right away, who can then advise you, because you can then, that's attorney-client relationship. They can advise you whether you should talk to the police or not. They can hear your story, and they may say, yeah, go ahead and talk to the police. That's okay. Or, no, I don't think you should. And during the interrogation or the questioning, the solicitor's there to make sure those kind of things like being lied to on those can't happen. Now, I'll give you an example of another thing that can happen in an interrogation in this country is, suppose you are invited down to talk about why you didn't show up for a ticket that you had been served, right? We want to talk to you about not showing up. And you likely go down, okay, I can work all that out. And the first question they ask you is, where were you on July 15th when Sam was killed? Whoa, wait a minute. See, now if a solicitor is there, boom, end of interview. We're leaving, that's it. You're not talking about what you said you were bringing him down for. Interview over. So that's how the interview and interrogation works there. I really like that approach, is so that the individual suspect can get advice whether to talk or not right away. Yes?
So how can you be sure that the solicitor is not on the tape or what?
Well, okay, I can give you some reasons why that is the case. One is they have no elected prosecutors or professional prosecutors or judges. They're not elected. So the solicitor is under no pressure to give any kind of advice, except fair advice. They're being paid either way. And if they're not working for the prosecutor's office, in this country, you've got elected prosecutors. Think of the pressure on that. If you don't have a sufficient conviction rate, you're not going to get reelected, right? So the pressure is convictions. You don't have a professional prosecutor's office in England. Barristers, as I said, are sometimes prosecuting and sometimes defending. And when you're a prosecuting barrister, there's no pressure one way or the other. Your salary isn't going to depend on getting convictions, right? You get paid. And in England, most people qualify for legal aid. So you're a plumber or you're a janitor or whatever, you have a job, they still will pay your legal fees, which takes that burden off. And that ties into the bond issue too. In this country, if you're charged and they may say you've got to pay a bond or we're going to keep you in jail. So the bond may be, let's just say, reasonably $10,000. If you can't pay the $10,000 yourself out of your pocket, which a lot of people would find that difficult, right? You go to a bondsman and you say, bondsman, I need $10,000 so I get out of jail. And the bondsman says, fine, yeah, I'll give you $10,000. You have to give me $1,000 to get that $10,000. Even if you're found not guilty, the bondsman keeps the $1,000. In England, almost everybody is let out without a bond, as long as they're not a danger to other people or to themselves, or flight risk, real flight risk, and then you'll sit in jail. But then most people are out and then have to show up for the trial. But you don't keep people sitting in jail.
So again, you say that barristers do both sides. So there's no barrister that becomes like...
Doesn't have a dog in the hunt, is what I would describe that way. They don't have a dog in the hunt because they do both sides.
Well, but so there aren't some that try to specialize, like to get a reputation, like I said, like Johnny Cochran, I'm the best.
No, I'll tell you how barristers are picked. Solicitors do the picking. And they have what's called a cab rank rule. The person who controls whether a barrister is going to get a job or not is the clerk of chambers. The clerk of chambers has enormous power. The solicitors go to them and say, do you have any barristers available? If a barrister's trial date is open, and let's say you come, your solicitor comes to the chambers and says, is Dennis Turner's case open on these dates? There's going to be a trial. And they say yes. Dennis Turner, as barrister, has no say, but I have to take you on as a client. It's called the cab rank rule. It's like in the airport, the next person in line gets the next cab. That's the same thing. So you have the situation in England, which I was able to see, is the most poor, down at the heels defendant may have one of the best barristers in the country if their diary was open on that day.
But the converse is also true. I don't, let's say you have the ability to hire a great barrister, you don't get to do that, right?
You have to go to a solicitor, but you could do this. A solicitor has their favorites. I mean, that if you got a solicitor that's always wants you, then that helps, right? Because barristers only get paid when they're litigating. So we did have as a client, one of the more obnoxious clients we ever had, who owned a series of appliance stores throughout England, had the money. Now, the advantage is that we don't have to depend on public aid for that. We could charge him 250, 300 pounds an hour for work. But he still didn't choose the barrister. He still had to go to a solicitor. He may say, I've heard about Jeffrey Still. I think I'd like to get him. And if Jeffrey Still's diary is open for that day, Jeffrey doesn't have a choice. He's got to take that client. And that. Yes?
I mean, I like a lot of what you said about the British system. Where would ours might be better? In what way?
Well, I think one, at the interrogation, I think, first of all, we shouldn't be electing prosecutors and judges. I had a lot of conversations with judges in England, and judges in England are more proactive. Now, they would argue that with all their experience, first of all, you got to be a barrister for 20 years before you can even consider to be a judge, and then you have to get approval through of other judges to get you to be a judge. Sometimes they kind of weigh in. They have to sum up the evidence, which gives them the power to do that. So they may give jurors the benefit of their wisdom at some point. And because they feel like, with all my experience as a judge, what's wrong with us sort of helping the jury understand things? Because I've had all this experience. And they have various ways of doing that. So I pushed back on the judge. I said, boy, if judges did that in this country, they'd get reversed all the time. Because in this country, if you say anything that looks like you're suggesting to the jury to come out a certain way, you're going to get reversed on appeal just like that. So judges here give boilerplate instructions. They want to avoid that. And the judge said, what? And this was a high court judge that I was talking to, the equivalent of almost all a Supreme Court judge. And he says, what? He says, you mean all that experience that the judge had, you just, goes out the window? And he says, well, how do you choose your judges? I says, well, they're elected. He says, oh, now I understand. Because you have somebody who can be connected politically, get to be a judge.
But doesn't that actually kind of, whenever you have a system like that, you start getting into groupthink. I mean, the people all come from the same place, they come from the same backgrounds, they're all barristers, they probably come, a lot of them from the same schools, and so, as they move in, it would seem like you're going to have more similarity of opinion than you might have in an elected system.
I agree with that a lot. Because I call it the old boy system.
Absolutely.
And it really worked against women for a long time. There's only 4 inns of court, and you have to be admitted to one of those inns to be a barrister. And where you went to school and that. I mean, one of the things that surprised me is they're still wearing their high school ties. And right away, if the ties match, whoa, all right, we both went to Eton, and this sort of thing. And that there is a good old boys network. It has been breaking down a lot, but I saw that. Now the British, I'm kind of an iconoclast in the ways, they like to think that the class system has disappeared. But coming in from the outside and seeing there is still very much a class system. If you've gone to Oxford, Cambridge, or the private school, we would call them, or public school, we would call them private schools, Winchester College or something, you have a status that nobody else has. And they're not so annoying about it because they're self-deprecating at the same time. But
it's still underneath.
That they have that sort of extra status. And I tease Jeffrey all the time about that because, you say that there's no class system anymore. But all you have to do is hear people talk. It's like, My Fair Lady. And you are in a different class. I also think that we Americans increase the IQ of anybody, especially a male, and there's been, who speaks with the British accent, with the Oxford accent. We immediately think they're 10 points higher on the IQ, right? Just because of the accent.
So, in your opinion, in the interest of justice, which system is the better?
Well, there's good and bad. I will give you the bad side, the one bad side of the thing that really bothered me in England is it's foundational. It's a foundational thing of our system about your ability not to have to testify against yourself. You cannot be a witness again. I mean, that's a fundamental right in this country. Well, in England, they don't have a constitution. All the rights are determined by legislation, and what legislators grant, they can take away. So fairly recently, they've changed the ability of a prosecuting barrister to comment on the fact that the defendant did not take the stand. And here's how the comment goes. I mean, it's deadly. Ladies and gentlemen of the jury, there's just 10 small steps from where the defendant is to the witness box. Just 10 small steps. If that person would take those steps, I'm sure there's a lot of questions you could have answered and I could ask and we could get answered. But they're not taking those 10 steps, ladies and gentlemen. So much for the right not to testify, right? You're toast either way. I mean, if you don't, they're going to say, well, you're obviously hiding something. And if you do, you're going to have to be subjected to cross-examination.
But at the same time, we see so often, at least in the TV, but even in stuff you see where people take the fifth, and I think a lot of people assume, oh, well, you're hiding something.
True, but where they take the fifth is not in the courtroom. In other words, you cannot call a defendant and then have them take the fifth, because that's the same thing. It's like commenting on their not doing. You can't even mention the fact that they did not testify and that. So they take the fifths in the preliminary type of things. So thank you so much for being a great audience and asking questions, and I'm